Lawyers, what happened when you were outplayed by your own loophole? Story 1. Lawyers scammed me and my family to the point where we're seeking recourse in court. I left the lawyer a 1-star review, and the lawyer threatened to sue me for defamation. It was all true, if I didn't remove that review. It all backfired as I added that fact to my review. Now, the lawyer is getting tons of upvotes on my review, and random 1-star reviews harassing him from everywhere. He even got a 1-star review from the Northwest Territories of Canada. They're so secluded from the rest of Canada that I didn't even know, in my naivete, that they spoke English up there. The lawyer who did me wrong is now laughingstock. Edit. Wow, I was not expecting this to get this type of traction, hence the very hasty language on my post. Thank you for your support. So, in light of having reviewed your comments, I feel the need to address a few things. First of all, yes, I filed a grievance against this lawyer, and yes, the local law society per bar association reprimanded him, but no, this lawyer did not give my family and myself the money that we had been scammed out of back. So that's why we're headed to court as well. Second, we've got a good number of family friends who are lawyers and who have had minor input on the case. All have agreed that this lawyer has no leg whatsoever to stand on, because everything this rotten apple in the legal community did was in malice, and there is no defamation in the review whatsoever. Lastly, someone from the Northwest Territories left a comment, and I just wanted to clarify what I meant by the NWT being so secluded. By all objective measures, the NWT is described as very remote online. However, y'all rock, and I love you Northern Canadians. And if you're reading this, JS from the NWT, you're a legend, my friend. I'm sure I'll do an updated post after the final verdict is delivered in court someday. As a honorable mention for comments, I'll note that the vast majority of lawyers out there are still great people. Story 2. Posted this on /Ask Reddit a while back, and somebody suggested I should cross-post here. Update. Lots of folks are asking the same questions, so I am editing this post to answer some. You will know them by the brackets and frequent use of the phrase, "Oh, for heaven's sake." Financial advisors employed by a pretty major bank stole all the money of a wealthy old lady who was dying of Alzheimer's, and she didn't know anything until her lights were cut off. My brother was a pretty small-time lawyer and got the call to represent her. Every other big-time attorney in the area had either passed on the case or tried and failed to get anywhere. When you're up against a legal team that makes a collective $10,000 per hour, it's not easy. For heaven's sake. Maybe it wasn't $10K per hour to penny, give or take $1,000, and you get the point. And since banks always have mandatory arbitration clauses worked into their contracts, she couldn't sue or even do discovery. For heaven's sake, proper discovery then. Discovery as it ought to be. Like, it was obvious what had happened, and the only people with access to the account were clearly implicated. But A, it was hard to prove without any access to bank records, and B, under arbitration, it wouldn't matter anyway. They could be criminally prosecuted, but the bank wouldn't have to pay back the money. Did I mention the bank had, at this point, frozen the lady's access to her own accounts due to fraud, so she couldn't even get her own bank statements. FINRA did not really apply in this case for many reasons that I never understood properly then and neither remember nor care about now. Anyway, my bro became pretty obsessed with avenging this woman. By the time he got the case, she barely even knew what her own situation was most of the time. But her son just wanted to make the bank bend over, and my brother was all in. He managed to find an incredibly obscure technicality that nullified the arbitration clause and was able to force a major bank into the discovery process. That alone was a huge enough deal that the decision was written up in many legal newspapers. For heaven's sake, journals figure it out across the country. The technicality, in TLDR form, was that the bank failed to keep an original copy of the contract, so they couldn't prove there was an arbitration clause. It is apparently normal for them not to keep originals, but in this case they didn't even keep reliable copies, and neither person who signed the contracts could be deposed under oath to determine whether the clause existed. So the judge just threw out the clause. The obscure part was that the copies were almost exact duplicates of the original, but a few words had been changed, and the pages were renumbered, and he caught the differences and pointed out that they weren't true duplicates. It wasn't really a loophole in the law so much as a flaw in the bank's bookkeeping. After fighting and delaying discovery until the very last minute, the bank dumped 200-plus boxes of documents on my brother the Friday before the Monday discovery hearing. He had 72 hours to go through tens of thousands of pages of documents. For heaven's sake. Is it really that unbelievable that a lawyer would try to keep a case moving along? Turns out he didn't need the continuance so many of you experts claim he would have. This attitude explains a lot about a lot of cases. Story 3. I used to work in the claims department for one of the top auto insurance companies in America. I get a phone call from a lawyer looking to file a new accident claim for his client. His client is also my customer. I explain that I can take the initial report from the lawyer, but will be contacting the client to get his side of the story. The lawyer immediately tells me that I am not to contact the client, because he is being represented by a lawyer. I explain that until I have an official letter of representation on file, I have every right to contact the client. So anyway, I proceed to gather all the details from the lawyer. Once I finish filing the claim, I generate a claim number and give it to the lawyer. The lawyer was stalling me a little bit, and I soon realized why. He was using the time to get an official letter of representation on file so I couldn't contact his client, also my customer. Which he did, and now I'm not able to speak with the client unless given permission by the lawyer. The lawyer was a total pompous ass and was definitely trying to throw his weight around just to show he was important. He definitely thought he was putting me in my place. He proceeds to tell me that the client has minor injuries such as back and neck pain and is going to see a doctor. I explain that the client may see whatever doctor he wishes, but that it's best to have us get in contact with his doctor of choice as soon as possible, so we can start using the coverage to pay for any medical bills. The lawyer gets all huffy-puffy with me and tells me that the client will go see a doctor and get all the medical help he needs, and once it's all done and over with, he will send us a bill that we will be required to pay in full. I explain it doesn't work that way. Some doctors require certain payments from insurance companies up front, or at least be in contact with the insurance company to confirm certain payments will be paid. I also explain the client only had a certain amount of coverage that he pays for. We are not required as an insurance company to pay more than what the client has on his policy. For example, if the client has $10,000 in coverage, we would only pay half of a $20,000 medical bill. I also explained that if the doctor hasn't been in contact with an insurance company, they may charge the client, and the client will have to go through a different, longer process for us to reimburse him than if we just paid the doctor up front. Now, I know this sounds like a bunch of corporate BS, and it is, but I don't make the rules. I'm really trying my hardest to make this as easy as possible for the client, but the lawyer just isn't having it at all. The lawyer demands that the client will go see whatever doctor he wants, and will receive whatever treatment he wants, and that we will pay for it in full, and the client will pay nothing out of pocket regardless of the cost of treatment. I went back and forth with the lawyer, but eventually you gotta understand that you're just going in circles, and it's time to just take the loss. So I do, and we move on to the vehicle. Lawyer says it's damaged, but the client drove the car from the accident scene to straight to the lawyer's office. The windshield was damaged, and there was fluids leaking from the car. I recommended that we tow the vehicle to a repair shop. I explained the customer had towing coverage and we can get a tow truck free of charge. The lawyer refuses and says the client can drive the car. The lawyer also demands that the client uses a repair shop of his choice. I explained to the lawyer that the client is absolutely allowed to use a shop of his choice, but that we have to send an adjuster out to the car to inspect the damage and give a quote to the repair shop. The reason we did this is a lot of times body shops will take advantage of insurance companies cause they know we will pay, and the shops fix things that don't need to be fixed and purposely buy more expensive parts to hike up the price. It's pretty much insurance fraud. So we usually send an expert of our own out to assess the damage and write up a fair and legit repair estimate. The lawyer refuses and says that he isn't telling us the shop that the car is going to, and once again, we will get a bill once all the work is done and we will be required to pay the full bill regardless of the price. I explain that we do not cover the cost. Story 4. As people have said, loopholes are rare, but this story jumps to mind. Wouldn't take much embellishment to make a dramatic TV moment. Convicted criminal was on furlough. A program with the jail where you can be released on an ankle monitor while still serving your sentence. He cut the monitor, ran, and was caught. Indicted for escape. Case gets to trial and the prosecutor puts on a pretty straightforward case. People from the jail and ankle monitor company and arresting cops testify. Then the defense moves to dismiss. Prosecution has failed to prove escape. There was actually a different law called unlawful evasion that applied to escaping off furlough program. This was extra confusing because escape is the correct charge for cutting an ankle monitor if you are serving your sentence on ankle monitor, which you can do sometimes. But if you start in jail and get out on an ankle monitor as part of a furlough program, then the crime is unlawful evasion. Prosecutor was furious because the defense could have dismissed the case at any point, arraignment up to trial. But he never said anything. So the guy sat in jail for months, awaiting trial on a charge he could get dismissed. Judge ordered the case dismissed. There was some small debate about whether he could be retried or not, because did double jeopardy attach if he was never actually charged with the right crime? But the DA wasn't going to highlight the embarrassment and just let it go. A crime and slam dunk case with a 6+ year sentence dismissed for a few months in jail. Story 5. I've got a good one. My lawyer friends and I talk about this all the time. Major miscarriage of justice, IMO. Bit of a long story though. TLDR. I convinced a judge that while my client was a drug distributor who admitted that he distributed drugs regularly from a house where drugs were found, the state couldn't prove that the drugs in question were his. Client accused of possessing drugs with intent to distribute. Police get a tip that drugs are being distributed from this house. Police surveil the house, see hand-to-hand transactions. Police send an undercover officer, who is able to purchase drugs at the house. Police get a warrant, raid the house. Police find inside the house a bunch of drugs on the living room table, a bunch of stuff suggesting the drugs are to be trafficked, e.g., scales, small bags, and like 12 people including my client. Police interview my client after reading him his rights, and he confesses that he is a drug distributor who distributes drugs daily from that house. Officers testify to all of this at a probable cause hearing, where the state must show that there are reasonable grounds to believe my client is guilty. I want to emphasize here that the state does not have to prove guilt at this hearing, much less guilt beyond a reasonable doubt. This is not a trial. The state just has to show a judge that there is some evidence to suggest my client is guilty. I make the argument, at my client's insistence, that although he confessed to being a drug distributor, he didn't admit that the drugs in the living room were his. It could have been the drugs of any of the 12 people present that day. The police failed to establish where he was in the house at the time of the raid. He might have been nowhere near those drugs. Who knows whose drugs it were? Judge agreed and dismissed. I remained stunned. Why I distribute drugs from this house, but those drugs, not mine, worked as a defense, not at trial, but at a probable cause hearing. Essentially, the judge ruled that it was implausible that my client possessed those drugs. Just an absolutely stunning ruling. Prosecution appealed. I had literally no argument I could present. Trial court was obviously wrong, but the reviewing court totally dropped the ball. Judge clearly hadn't read any of the briefs and said she needed time to review everything before making a decision. Months later, prosecution follows up, and the clerk reaches out to me to ask for new copies of all the documents in the case. The court had lost the case file. I provided the docs, and the next day, the court issued a judgment, saying, quote, "For the reasons stated on the record, appeal denied." Remember, there were no reasons stated on the record, because the judge had no idea what was going on, because she hadn't read anything. Prosecution appealed again, but the Michigan Court of Appeals declined to hear the case, probably because it's a minor drug case out of Detroit, and they have better stuff to do. So the dismissal was upheld. My client went free, presumably to distribute drugs, but not those drugs, from another house. Story 6. The ghost. Okay, so, in the first place, it's always nice to get a client from a business card you left at a diner. It means people pick those things up. However, when leaving business cards at diners in certain areas of town, I should expect some issues. This call came through on a dreary December day as I was sipping coffee and watching the snow fall. The caller ID read that it was the local hospital, and as I picked up I spoke to a rather frantic young man who informed me he was being held against his will and he needed an attorney to help him. When I asked where he was, he simply said, "The 5th floor." While this may sound innocuous, every hospital has a 5th floor, where Napoleon roams the halls freely, and the residents speak to their imaginary friends who may, or may not, have been an influencing factor in why they decided that clothing was a way for the government to track them, and therefore the only solution was to create poop pants to throw off the monitoring ability of the CIA. Long story short on this portion, within an hour of the call a friend had dropped off my fee, and I was en route to the 5th floor to meet with my new client. I assumed it would be an involuntary committal defense, and after speaking with my client, I gauged that while the man was most definitely in need of mental care, he was not a danger to himself or others, and was unlikely to be one. He had, in my opinion, been forced to agree to being committed by his probation officer, and frankly I wasn't going to let that stand. I got the name of some contacts from his treatment plan who were willing to vouch that he had, until recently, been compliant with his medications, and contacted his social worker, who was able to confirm that, yes, since he had ceased taking the medication due to an inability to afford the medications, the county would assist him with it. A slam dunk, I would simply swing my big lawyer authority around the mental ward and get him released, then appear in the court to defend against the involuntary committal. Within 24 hours of being committed, my client was back at home. A hearing was set a couple weeks in the future, and I did daily checks to be certain he was compliant with his medication leading up to the hearing, until the one day I didn't. A call from the local police was my tip-off. An older officer, one I was familiar with, called to advise they had responded to a disturbance at my client's home. He apparently had been screaming in an empty room loud enough that the neighbors were concerned and called the police. The police officer, a friendly sort, gauged the situation and decided my client wasn't a threat, but asked what the situation was. The ghost? My client had responded, "The ghost won't get out and it won't leave me alone." "Well," said the officer, "I can tell it to leave." So he did. He told the ghost to leave, and then, apparently for fun, told him that it was a, quote, a civil matter if the ghost refused to leave, and therefore an attorney would need to be contacted, at which point my client dropped my name, which resulted in the cop giving me a heads up. So I call my client Dot, who is inconsolable at the concept of sharing his home with the ghost. Keep in mind, I've been to this guy's house. This is the first I've heard of a ghost, but there is a competency hearing on the horizon, and this will not play well in front of the judge. The cop said it's a civil matter. My client repeated about the 18th time after I told him I was not, in fact, a priest, but was a lawyer and didn't know how to perform an exorcism. "What do you want me to do?" I snapped a bit. "Evict it." There are moments in time when you should keep your mouth shut. This is one of them, because the immediate response was, "Can you? That'd be great." Well, so, long story short, I ended up driving out there with a mock-up notice to quit, addressed to any spirits in possession of the property located at 1313 Mockingbird Lane without any authority under color of law, advising them that their possession was unlawful in nature, and ordering them to quit and surrender the premises, or any portion thereof, within 15 days of the date of this notice. As I was obviously unable to obtain personal service via hand delivery, I had my client direct me to the portion of the premises the ghost occupied, an empty spare bedroom, and made service by posting the notice to the door of Story 7. This happened many years ago, but I was just reminded of it last night by a former coworker. I got my degree in business with a paralegal minor. Worked as a paralegal for a few years before moving to a new city. Upon arriving in new city, I found that legal secretaries got paid OT while paralegals didn't, and with very similar base salaries and similar work hours, at the end of the day the legal secretaries made more money. So I took a job as a legal secretary. I worked directly for 2 attorneys. 1L had a couple years experience, knew I had education and experience to be a paralegal, and utilized me as such. Other B was fresh out of law school and newly passed bar exam. He had a massive "I'm the lawyer" chip on his shoulder. One day named partner, NP, who was notorious for flying off the handle at mistakes, assigns B to prepare some legal documents. Instead of saying, "Hey, NP needs documents on this file to handle this issue," and having me do them, he takes the time to actually dictate the documents. As I'm working on them, I realize he's made a logistical mistake. He drafted the document in a way that would result in it not being legally enforceable. I go to his office and explain, "Hey, I was working on this and I noticed X, and that's not how that works. You need to have it do Y instead or it won't be enforceable." He says, "I know what I'm doing and that's the way it needs to be done, so just do it as I dictated it." Yep, of course, absolutely. I did it his way, reminded him when I handed it to him that we'd had prior conversation and that I'd completed the document exactly as he'd wanted it. He happily nods, and off he goes to NP to give him the finished work. Less than 30 minutes later, NP is in B's office doorway, throwing a hissy fit that document was prepared that way. "You can't do that? You've literally made this document worthless, blah blah blah." I sat out in my cube and hid behind a piece of paper while NP told B to prepare the document exactly how I'd told him it needed to be prepared. I wish I could say that going forward B listened to me when I raised concerns, but he only lasted a year and in that time never lost the "I'm the lawyer you're not" attitude. Meanwhile, years after I left that job, joined corporate world, and moved up in my career, I was still close with NP, who actually referred my company business, and I attended his funeral when he passed a few years ago. Story 8. This chain of events started almost 20 years ago, and involves myself and a notoriously snooty national real estate agency. There is a bit of background leading to the MC incident, so please bear with me. This all occurred in QLD, Australia. I once rented a property through an agency from 2004 to 2006. Due to my ex-partner's explosive and violent temper, we had been handed an eviction notice. There was damage to the property that was unfixed at the time we were evicted. Damage that was in the form of fist and hammer-sized holes in walls, etc. We obviously did not receive any of the bond deposit back, as the repair costs more than absorbed the amount. There was also an added sum of about $1,700 extra to cover the rest of the costs incurred repairing the damage. This amount was forwarded to a debt collections agency. This collection amount was in both of our names, as we had jointly been on the lease agreement. I was not upset at the agency. They were just doing their job by being a good advocate for the owner of the property at this stage. Taking the bond and charging us for the repair was standard and not nasty, vindictive, or overkill in the slightest. My anger came later. Although I must admit I was a bit miffed to be duly held financially responsible for the damage caused by my ex, but due to the nature of the joint lease, not much could be legally done. I was just grateful we had parted ways not long after. A few years post-eviction, I wanted to get my life more organized in many areas and tie up any loose ends that would impede me moving forward. A clean slate, so to speak. So the debt issue came first. After many phone calls and some paperwork exchange, plus an escalation or two, the debt collection agency finally agreed to split the $1,700 damages bill between the ex and myself. Now I could pay off half and not be held accountable for his portion any longer. This had to be done without his consent, as he refused. I'm unsure as to why, possibly hoping I would pay the whole lot to rebuild my credit rating, or most likely just to be annoying. Once I had paid off my portion of the collector's debt, I thought I was done with the whole business and the black mark against my name. Not so, unfortunately. It turned out that the state I lived in had a blacklist that real estate agencies and lessors could add tenants' names to. It's called the TICA list. All they needed was proof that the tenant had behaved in a bad enough manner regarding renting of a property to warrant being listed. Due to the fact we had been evicted, the damage, and also owed arrears to a debt agency for repairs, we unfortunately qualified. Being on this list made it almost impossible to rent, especially via a real estate agency. After speaking extensively with the RTA, which is a government agency, I found I was definitely eligible to have my name removed from the list, so I started taking action for this to happen. I was able to demonstrate good faith by having paid for half of the damages. It also went in my favor that my partner was abusive, and there was legal evidence of this fact. However, I was told the only way to have my name removed was by the real estate agency, so I approached them and asked for them to do so. They were very helpful initially. If I was able to show them proof that the debt was settled, they were happy to remove my name. At least 7 years had elapsed by this point, so it was considered punishment enough. At the time, after 5 years, your name is usually removed from the TICA list. However, this company apparently kept tabs on who they had added to the list, and when the person's 5 years expired, they just added them again. Dirty tactics indeed. Obviously, I had been re-added. So I provided relevant paperwork, including the abuse evidence, and waited. And waited. And waited. After several weeks, I contacted them again and asked what the holdup was. I was told my paperwork was in a queue to be processed. I waited a few more weeks, then contacted them again. This time I was told my file had been misplaced, but they would look for it. A few weeks later, I contacted them again. This time they told me they had found the file, but it was in a queue to be processed. I waited a few more weeks and contacted them again. This time they told me the file had been misplaced, but they would look for it. I saw the pattern and decided to escalate. I contacted the head office and asked for the manager. I explained the situation and asked for assistance. The manager was very apologetic and said they would look into it. I waited a few more weeks and contacted the manager again. They told me the file had been misplaced, but they would look for it. At this point I was getting frustrated. I asked the manager what I could do to speed things up. They said if I was unhappy with the process, I could take them to court. Okay then. I filed a claim in small claims court for $35, the filing fee, and served the agency with the papers. The agency suddenly found the file and processed it. They removed my name from the TICA list and sent me a letter confirming it. But that wasn't the end. The day of the court hearing arrived. I showed up with my letter from the agency confirming my name had been removed from the list. The agency sent a manager and a lawyer to court. The judge asked me what the claim was about. I explained the situation and showed the judge the letter. The judge asked the agency why they had not removed my name from the list sooner. The manager said they had been busy. The judge said that was no excuse and ordered the agency to pay me $35. The agency paid me $35 and I was done with them. Story 9. In terms of loopholes, my criminal law professor was also a practicing criminal defense barrister, and he told this story about a case he had won. The event happened in the city of Jervis Bay in Australia, which is notable because it's an annexed part of federal land so that our capital territory can have an active port. My professor's client had gotten into a fight on the beach and, in knee-deep water, proceeded to severely beat the guy he was fighting. Assault charges were laid and it went to court. My professor managed to find that, at the time, the delineation of the federal land around Jervis Bay ended at the high water mark. Also, at that time, the delineation of the coastal region belonging to the state ended at the low water mark. He managed to show that, because the crime had happened in between these 2 points, neither the state nor federal court had jurisdiction to try the client, and he got off. Obviously, the definitions were amended after that so that there would not be such a gap, but that one guy got through. Story 10. Not me, but a professor I had, who specialized in advocacy for victims of human trafficking, basically helping victims of trafficking avoid deportation. A salon was raided in connection to a suspected human trafficking ring. The tip turned out to be accurate. Multiple people were arrested, and several victims were taken into custody. Among them was a 4-year-old boy. None of the victims knew him. He helped clean the salon. Traffickers wouldn't say where he came from. The child didn't know his own name, where he was from, or where his parents were. When the judge asked the boy for his name, he replied, "Spider-Man." When they asked for his real name, he said, "Peter Parker." The prosecution wanted him removed because he was in the U.S. illegally. Here's the interesting part. There is a federal statute on refugee eligibility. This particular statute hadn't been cited in over 60 years but was still valid. The statute essentially says, if a victim of human trafficking is an unaccompanied minor under X age and does not know their country of origin, they are to be granted asylum immediately, with no court discretion. My professor intended to cite this statute. The prosecutor was concerned about creating new case law and offered to drop charges if this statute wouldn't be brought up. The professor agreed, in the best interest of the client. In a twist of fate, the prosecutor passed away, and the newly assigned prosecutor said he would not honor any pre-existing deals. The professor said, "Fine, let's make some case law." The new prosecutor panicked and asked to revert to the original deal, which was accepted. Interesting example of how old statutes can still have a big impact. Story 11. Colorado's Make My Day law. I was a prosecutor in a small ski town. One of my regular customers was psychotic, who often caused trouble and annoyed people. How he got a girlfriend, I'll never know. But he did, and his GF had a roommate who was breaking up with her boyfriend, another difficult person, who was not taking the breakup well. One morning, the ex-boyfriend entered his ex's apartment uninvited and threatened her. Psychotic was there with the roommate and intervened to stop the situation. The intruder was restrained, and the police were called. The cops handed this case over to me, and I became acquainted for the first time with Colorado's brand new Make My Day law. I had to explain to my sheriff and chief of police that this time Psychotic would not face charges. The Colorado legislature had declared that if someone unlawfully breaks into your home, you are allowed to defend yourself. The law is very broad and protective of homeowners. I would have been more concerned if I hadn't been sure Psychotic would be back on my plate. And sure enough, he went off to the state pen eventually, but not for violent crimes. Story 12. I had a case against me thrown out when body cams were brand new, and a cop had filmed himself being absolutely adamant about why they were searching my friend's car, which didn't actually have any legal backing, and then they wrote a different reason in their report, and the judge was all, "Ooh no though." The prosecutor had been yelling about putting me in prison for 10 years, all the while it was not my gun, and legal anyway, not my drugs, and trust me, that was a wild week. If we'd known those drugs were there, I swear to God we would have used them already. I did have my own pants on that day. All's well that ends well. Cops didn't get fired for illegal searches, though, of course. Story 13. AM criminal defense lawyer, client arrested on DUI. Client lived in small town. He and his wife would drive to the one bar in town, drink, then walk to their houseboat after a night at the bar, 1/4 mile away. He and wife know everyone in the bar, another patron they know gets blasted, bar owner says she can't stay, client and wife walk her to his car to stay there until ride comes. Client gets her in back seat of the SUV. Client is drunk, drops keys on the way to front seat, opens now unlocked front door, turns on car lights to see he walked around the front from rear passenger. Cops are waiting to see if people leave bar drunk, sees lights, says he saw driving, immediately rolled up arrests client. Client has prior DUI from 12-ish years before. Judge agreed that it wouldn't come in, jury wouldn't hear it unless he, quote, opened the door. Can't win the case unless dude testifies. I prep him, continue to prep him, keep prepping him, but tell him under no circumstances can he say he would never drive drunk, never do anything like that. Basically anything about the past equals no. Direct is going well. Gave him a beautiful, easy last question where he could explain the night, explain why he was upset he got arrested, because he wasn't driving and was doing everything right. I would never do something like that. Door open, judge lets the in rebuttal bring in old Dewey. Jury took about 25 minutes to convict. And that's about one of 100 stories. Life is never dull in the criminal defense world. Story 14. I'm not a lawyer, this isn't my story. But the lawyer who handled my business stuff and a legal dispute is a federal judge. Before he became a judge, he was a lawyer for divorces and civil matters. A wealthy male client filed for divorce. There's a prenup. It's pretty ironclad. It discusses the distribution of wealth. The alimony, if any, is laid out at a set amount, increasing yearly based on inflation. There's one major exception. If you violate the terms of the prenup before the divorce is final, you automatically face the worst conditions. In the woman's case, she gets zero alimony and a one-time payment of $100K. In the man's case, he loses the main family home, all cars that are not his daily driver, and 1/4 of his business. A buyout option is available, but it doesn't matter to this story. The lawyer gets to court and meets with his client in a conference room. The client is beaming. He shakes the lawyer's hand and says, "Hey, Mike, I want you to meet Jasmine. I met her 2 months ago. She's amazing. We got engaged over the weekend in France." And Mike shook her hand, slumped in the chair, and said, Story 15. I worked for Insert Major Airline and discovered through a mind-numbing contract review that they were double-dipping. They had entered into an exclusivity agreement with one Insert Major Airline repair provider and, without informing me, had asked me to engage in a separate exclusivity agreement with another provider so they could get a second $25 millimeter rebate. They intentionally had 2 separate attorneys on each transaction so we wouldn't know about the double-dipping. I don't know if $25 millimeters sounds like a lot to you, but when you're talking about airplanes which cost millions, I am not going to get disbarred so you can make a little extra money. I quit on the spot. Story 16. Represented a dad requesting more parenting time. Part of my approach as a lawyer is to work with clients as we go to testify. We don't have a big prep session like on TV. I correct their responses as we go so they testify properly. This works great for most clients. They usually adjust how they speak to their co-parent and how they think and act. I told this dad that his final hearing was set for X day for 3 hours, and that it was the mom's petition, so she goes first. I reminded him to answer questions as discussed, and if he could say yes or no, to just say yes or no. The hearing went fine. The client refused to admit he is an alcoholic, but attends AA a few times a month. This was news to me, as I only learned about the denial before the hearing. We left court after he was granted more parenting time, but he got chewed out for being difficult. Justified. Client said, "You didn't tell me I would have to testify." Lesson learned. Always use the word testify. Don't just explain the process. Story 17. It wasn't a client, but I had an expert witness go WAAAAY off the rails during cross-examination during a week-long trial a while back. He forgot all his analysis and data and just started spewing nonsense from his mouth. Then he became combative with counsel. Then he started making political statements. He was making nonsense left and right that was nonsensical and was getting cooked by counsel. I could see the delight in opposing counsel who was having a field day. My client stormed out of the courtroom, BC. He couldn't take it. I was facing the witness stand about 6 feet from our expert in total shock. We were absolutely crushing the case up to this point, and I was watching the scales tip the other way minute by minute.